Today's topic is trademark law. This is the third video in my series on intellectual property law. Previous videos covered copyright and patents. If you're interested, those videos are linked in the description below. My name is Konrad, and I'm a practicing lawyer here in Chicago, Illinois. On the subject of trademark law, I have litigated numerous trademark cases throughout my career and have helped many clients obtain trademarks. Now, if you own a business, there is a good chance that your brand is the most important and valuable asset that you own. Trademark is how you protect your brand. So if you own or operate a business, this is an important video for you. At its core, trademark is a way for businesses to indicate that they are the source of particular products or services. With that last bit, I can almost hear my trademark professor saying, "Trademark has nothing to do with services." And technically, that is correct. But as people tend to refer to the entire umbrella of marks, including trademarks, service marks, collective marks, certification marks, and trade dress as trademarks, and as that does not confuse anything important, I'm going to refer to all marks as trademarks. Now, specifically, a trademark is a word, phrase, symbol, design, color, sound, or scent that serves as an indicator of source. Source of what? Goods, services, what have you. Here are some well-known examples of trademarks. You probably recognize a few. Trademarks are literally everywhere, and they are extremely important to consumers and to our economy as a whole. In particular, everyone, you, me, everybody, relies on brands to deliver the products that we expect. Let's take Apple as an example. A lot of people love Apple products. iPhones, iPads, iMacs, MacBooks, iTunes, the App Store, the Apple Store, you name it. But if you think about it, a lot goes into being an Apple product. This is my cell phone. It's an Android device, OnePlus to be specific. It's a few years old, don't judge. I use this phone every day and I absolutely love it. I also use an iPad Pro almost every day. It has more or less replaced my laptop. Absolutely incredible device. But it is nothing like my Android phone. On the other hand, the interface on the iPad Pro is a lot like the interface on my kids' iPhones. It's the classic Apple interface. The point I'm making is that Apple products have a certain feel to them. They provide a consistent experience. When a customer buys an Apple product, that customer has certain expectations about how the device will look and how it will work. I dare say that an iPhone user would have no problem picking up an iPad or even an iMac and making it work. Apple has spent a ton of money developing the unique feel of their products, and even more money cultivating a customer base for the products. In fact, I bet that many people watching this video, maybe even most people, know what Apple products are, and what I mean when I say unique feel of Apple products. To put it simply, there is a huge demand for Apple products. I think it is also fair to say that if you put an Apple logo on a product, it is going to sell a lot more than if you put a generic logo on that same product. Now, think about that last bit just for a moment. An unethical company can immediately sell a lot of a product without spending any advertising money just by putting an Apple logo on their products. All the Apple fans are going to assume that the knockoff product is an Apple product, and that'll meet the same standard of quality that my beloved iPad Pro meets. So what is to stop an unethical company from creating a piece of junk product and slapping an Apple logo on it? Trademark. If, or should I say when, unethical companies slap the Apple logo on their trash products, Apple can file a lawsuit alleging trademark infringement and counterfeiting, among other counts. And Apple actually does file lawsuits like this more or less every year, if not every month. Now, you might ask why the law protects trademarks in the first place, and you might be surprised, but the reason that the law recognizes trademarks is to protect consumers. In particular, to protect people like you and me from having unethical companies effectively steal our money by slapping well-known brands on their products and passing those products off as if they came from those well-known brands. If someone wants to take cheap laptops and slap an Apple logo on them in his garage, Apple can sue the knockoff manufacturer for counterfeiting, a special type of trademark infringement that requires that the exact brand of a company is used without permission. Similarly, if a company wants to use a mark that is close to that of another company, think Apple Time instead of just Apple, then the brand, Apple in this case, can still file a lawsuit because the mark is likely to confuse consumers. But this lawsuit would just be run-of-the-mill trademark infringement as opposed to counterfeiting. Now, I have talked a bit about what trademarks are and why they are important. That still leaves how you get one. As I said before, there are a lot of different types of trademarks, and there are two more pools of marks that are important. Those are registered marks and unregistered or common law marks. Registered marks refer to marks that are registered with a government, be it the United States federal government, a state, or a mark that is registered with a foreign government. Unregistered marks are everything else. And that brings up a key point. You do not have to register a mark to have trademark rights. Instead, all you have to do to obtain rights in a trademark is to use that mark in commerce in association with a particular good or service. However, registration provides some valuable advantages. Let's cover some of the benefits of registering a mark with the United States Patent and Trademark Office. First, the main benefit of registration on the principal register of the United States Patent and Trademark Office is that a registered mark has a presumption of use in commerce for the goods and services recited in the registration throughout the entirety of the United States, including all territories. This presumption is an enormous advantage if a conflict develops between a business with a registered mark and a business with an unregistered mark. The company with the registered mark does not have to put forth any evidence about the use of the trademark at all. On the other hand, the business with the unregistered mark has to prove that it made use of the mark throughout the United States before the mark owner filed a trademark application. The presumption is why, even when an unregistered mark user arguably was using a mark before the registered mark user, the business with the registered mark will win the vast majority of the time. I don't know the exact statistics, but I would guess that in registered versus unregistered mark cases, the owner of the registered mark wins about 90% of the time. Even in cases where the unregistered mark survives, it is generally limited in territory, a few cities, perhaps a single state, and it is usually forced to coexist with the now much stronger registered mark. Second, once your mark is registered or even filed with the USPTO, it provides notice to the public that you are using the trademark or planning to use the trademark, and a lot of responsible businesses will go and look for something else. Registration also provides legal notice throughout the United States. So if another company comes along and starts using your mark after your application date, they cannot claim they're using it in good faith, which can be very important when a mark owner is looking to collect money. Third, the registration is evidence of the validity of the trademark, as well as the owner's exclusive right to use the mark for the goods and services reflected in the registration. And after 5 years, a declaration of incontestability can be filed, which makes these protections even stronger. Fourth, registration with the USPTO allows the owner to use the special trademark symbol. This symbol is reserved for marks that are registered with the United States Patent and Trademark Office. Marks that are registered elsewhere, and even common law marks, can use the TM symbol, which only means that the business believes that the mark they're using with the TM symbol is in fact a trademark. Fifth, a registered mark allows the owner to sue in federal court for registered trademark infringement, and it will enable, in some instances, enhanced damages, as well as enable the owner to take advantage of federal counterfeiting laws. Now, there are other advantages and benefits that registration gives you, but I think that my list demonstrates why businesses register trademarks and just how valuable they are. On that point, if you are interested in registering a trademark, I would like to shamelessly plug my law firm, the Law Offices of Konrad, Sherinian, LLC. We have filed hundreds of trademark applications for clients and can help you register your mark as well. My firm is linked in the description below. There is one more subject that I briefly want to touch on, and that is how long a trademark can last. While copyrights last a long time and patents last 15 to 20 years from the date of filing, depending on the type of patent, trademarks can last forever. Literally forever. Lowenbrau has claimed continuous use of its trademark since 1383, and Stella Artois, another beer, claims continuous use of its mark since 1366. Now, it's a bit odd that the two oldest trademarks I could find represent a couple of beers. I guess people really like their booze. That aside, the point is that as long as a trademark is used, it continues to exist. Now, I would be very interested in hearing what your experiences with trademark issues have been, and what kind of questions about trademark you might want to see me address in future videos. Have you ever ordered a product from Amazon and got back a clear counterfeit? Are you, in fact, an enormous counterfeiter, peddling millions of counterfeit goods every day? I would definitely want to know about that one. For now, however, that wraps up my overview of trademark law. If you learned anything from this video or found this video entertaining, a like would be appreciated. And if you are interested in more videos like this in the future, feel free to subscribe and turn on notifications. Have a fantastic day.